Hello, this is Dr. Schamberger, and in this brief, hopefully brief video talk, we're going to look at the criminal trial process, starting from when the trial actually begins, and then we'll take it all the way up into discussing issues regarding appeals. So in a criminal trial process, we have two phases actually. And sometimes this can take a week. It depends on the case, and sometimes it can take 2 weeks, sometimes a month. You never know. But it does start in the first phase, which is to determine if the defendant is guilty or not guilty. Assuming that the defendant is guilty, then it goes into phase two, which is then the penalty phase. We'll talk more in detail about these. There are opening statements in both phases. So the prosecution presents its case through testimony of witnesses and evidence. The prosecution usually begins first, and the prosecutor, again, likely will make an opening statement. All witnesses have to be in another room. So when one witness is called, all the other witnesses are not in the courtroom. And that's so that they're not being tainted or influenced or somehow modifying their possible testimony. In addition, the defense attorney will cross-examine the prosecution's witness. So when the prosecutor is finished with that particular witness, then that person is then handed off to the defense, where the defense has the opportunity to cross-examine. After that, it can go through a redirect, going back to the prosecutor. So sometimes prosecutors will do this, it's strategy for them, because some of the points that might have been made by the defense attorney through the questioning, the prosecutor is going to want to put the ball back in his or her court. So that way the jury hears last what the prosecutor has to say. So a lot of times they'll do this to try to reestablish some credibility in some of the evidence and the testimony. Now, the defense can also call witnesses, but the defense does not call witnesses until the prosecution has rest its case. The reason why we start with the prosecution is because the prosecutor has the burden of proof. They have to bring forward all evidence. They have that burden. That's the burden on them. That's why the prosecutor goes first. So they've got to present everything first because they've got that burden to try to demonstrate guilt on behalf of that defendant. But once the prosecutor has rest his or her case, then it's the defense attorney's turn to do the same thing, call witnesses, and then when a defense has finished asking questions of one witness, then it's handed off to the prosecutor to cross-examine. So it's the same on both sides. It's a mirrored opportunity for both sides to ask questions of their witnesses. Assuming that everything has gone through, we're going to jump ahead, but that's pretty much the process during that time. It's almost like a little tennis match to some extent, until we reach now the closing arguments. The closing arguments come after both sides have finished presenting all evidence and all testimonies. So once the closing arguments are complete, then the judge issues instructions to the jury to now go into deliberations to decide whether that defendant is guilty or not guilty based on the testimony and evidence presented in the trial. The jury could be sequestered throughout this entire criminal trial process if the case is high profile enough. So that is a possibility. In many of the local court cases, you might not see this, but again, it depends on the severity of the charge and the actual case itself. Now, what do you do as a journalist while they are in deliberations? You wait. You have to sit there and wait. You cannot leave the courtroom. This is where you need to have, again, bring your charger for your phone, have your computer, have everything with you, because while they are in deliberations, this is your time now to start filing, tweeting, whatever kind of updates y'all have to give for your website, whatever the news organization wants you to do. Maybe talk to some of the people who have, maybe family members who have been watching the case, and you still have to be careful about that. I once covered a case in which the family of the defendant, I won't say spent a lot of time with me, but again, this is where I believe media need to have a separate space from the actual courtroom, maybe a media gallery. Some courtrooms do have that. This one did not. And so where I was sitting, the family would talk to me, which was fine. And I thought I made equal opportunities to speak to the other family, which they declined to talk to me. But they were a little upset that I was talking a lot with the other side, with the defendant's family. It just happened to be where I was sitting. I was caught up on my work. This is pre-social media, so and also really before the heightened need of the internet and the website. But still, you have to kind of watch your surroundings a little bit, and making sure that if you talk to one side, try to give the equal time to the other as well. But in all of this, you wait until the jury returns. So if it happens to be close to supper time and you're getting hungry, you need to make contact, text somebody to bring you something, or you bring your own snacks and eat where appropriate in the facility. Now, anytime during the criminal trial process, the defense can make a motion for an acquittal or a dismissal of charges. If the defense feels that the Commonwealth failed to provide that burden of proof, in which they feel that maybe some of the evidence was circumstantial. I once covered a murder trial in Montgomery County, Tennessee. It was a high-profile case because it involved the disappearance of a Fort Campbell soldier. The body was never found. However, the jawbone happened to have been mailed to a TV station, to one of the reporters who became really close to the family of the deceased soldier. So the defendant, who was her ex-husband, and they were only married so that way she could receive some benefits. She was gay, so they married only so that way they could have some of the benefits of an actual marriage in the military institution. But there was no body. So there was only circumstantial evidence that, yeah, he could have done it, or no, he couldn't have done it. So there was, so the prosecutor, or excuse me, the defense brought forth a motion for a verdict of acquittal, and it was granted. The judge granted it. So and that became, of course, the big story. So what the Commonwealth, or excuse me, in Kentucky, we call him the Commonwealth's attorney, and again, in other states, it's the prosecuting attorney, but they have to establish what we call a prima facie case. That's one of those Latin words that you have to know. Prima facie means that it has to be presented at first glance. At first glance, that everything aligns well, that yes, all the evidence is in order, all the testimony really stems from the evidence presented. It all basically shapes up to be the truth against the defendant. So that's a prima facie case, and that's really what it means, is at first glance. At first glance, hardly any error could be ascertained that the defendant did not do it. So basically, that's what that indicates. So that's really important if it comes to that portion of the case. So when you are covering a trial, let's talk about how you really go about writing it. The first day, it's going to be focusing pretty much on the voir dire process, in which the jury is selected and seated. If possible, the judge will go ahead and move forward with opening statements, and that does happen. If not, the judge could recess until the next day. But either way, your first day is either going to be the voir dire and the opening statements and first set of witnesses, or maybe a combination of those. You will want to find a seat as close to the action. There are going to be times you have to remember, in a courtroom, even though they're speaking in a mic, it's not to amplify sound. It's just to be able to capture the recording effectively. So sometimes witnesses might not speak clearly. So you will need to try to get that front row if possible. Sometimes the seats or the benches in the courtroom could be blocked off for family members or for others. So do as best as you can to establish those relationships first with the judge as well as other courtroom officials, to see how you can be accommodated to cover the story properly. You want to focus on what's happening at that point in time. and in addition to what happened then, because you've got to include some of that background information in your story. It helps to fill in those middle graphs for the court story. Day two, it's all testimony. And you have to determine really what's the most important piece of that testimony. And this takes a number of directions. It could be something that one of the witnesses said. It could be a key witness. Maybe it could even be a moment in the trial. Maybe there was a lot of reaction, a lot of crying from the maybe a family member or something along those lines. So you have to determine what's going to be your lead angle in day two story. Of course, all these stories are going to be updated. So you might be writing a story at the moment, and you could actually then file another story later in the day. So it's possible you could have 2 or 3 stories coming out of one day of courtroom coverage. You continue this process until the verdict is issued in phase 1 of the criminal trial process. So after the verdict, if it's guilty, the defendant is guilty, then the case goes into the penalty phase. We kind of go through the same process that we did in phase 1. Witnesses could be called, but these witnesses might be family members. If family members of the defendant are present and are called to testify, they might try to paint a picture for the jury as to the what they remember lovingly, warmly about that defendant, in the hopes that maybe a lighter sentence could be given. So in your case, as a journalist, you're just going to continue this process of updating and reporting both on the news organization's website, whatever their publication might be, if it's a newspaper or a broadcast. You're going to be maybe tweeting updates, Facebooking updates, whatever your news organization has you doing. You'll continue this until the jury comes back with a recommendation as to what the length of the sentence might be. The judge is going to set the sentencing date once it's all done. When the sentencing date is determined, that's going to be pretty much your, for one of your stories, the latest story anyway, will be in that top half, because people who have been following the case are going to want to know when that person will be sentenced formally. Let's talk about sentencing. So even though a jury might recommend to the judge what that defendant should serve, judges, again, they have a range of freedom to act, and they're using this based on all kinds of law, both case law as well as what's on the books. So they're using a number of resources to determine what is going to be best for all involved, what's fair to both sides. So they can impose a prison term that is based on the defendant's history, nature of crime. Again, kind of similar to when they were trying to establish what the bail amount might be back in the early part of the criminal case process. Sometimes a judge might issue a prison sentence, but it could be probated. Probated on the grounds that the person is going to pay back restitution if there was a loss of money involved, maybe to serve some community time, maybe at an organization that a judge might feel could be helpful for the defendant in realizing even more what he or she might have really done wrong. So there are a number of things a judge can do. Obviously, one of the big arguments is that some of the measures that a judge may take for a defendant, are they really effective? Even a prison sentence, even 1 to 3 years, is that going to be effective? For some defendants it is, and some it's not. Is community service really necessary? Well, sometimes that's where some defendants will find kind of the answers to life, if you will. They realize what is more meaningful beyond them. So it depends again on the person, but these are some good things when you have time in this particular beat to, try to do some stories surrounding these topics. And then appeals. So just because a sentence is determined, and while the defendant may go ahead and serve that sentence, that defendant also has the right to appeal. This is newsworthy to really follow, because sometimes a trial court judge, so that circuit court judge that determined the sentence and formally sentenced that defendant, sometimes their rulings can be overturned. If that happens, if a state appellate court decides, well, yeah, there were some things that didn't go right in that trial, and so we're going to maybe overturn, or maybe we'll issue a stay, or there could be a number of things that an appellate court can do. So a lot of these appeals, when appeals are filed, it's not so much to try to appeal the decision. It's to deal with the matters raised at the trial. These are more technical. If you want to equate it to a ball game, it's like a technicality in a will, if you will. This means, though, for you, you've got to go back and look at what that lower court's decision was, and look at the written record. So maybe going into the case file, because by the time the appeal is issued, it could have been another year. So, a lot of time has already taken place, and of course that time has been filled by other projects that you are working on, and some of these details may become fuzzy. Um, and many times when the defense attorney for the defendant has filed an appeal request, they're making the claim that maybe the judge mistakenly, maybe not erroneously, but just mistakenly interpreted the law at trial. But again, it goes back to technicality issues. It goes through the same kind of process again, in that the lawyers on both sides are going to argue. So if an appellate court is willing to hear the appeal, then the prosecuting attorney also has to go and make a statement in this particular process. And then the case is decided by a panel of judges. So on appellate courts, you have about 3 judges, and so they're going to decide whether to grant the appeal or not. And that concludes this process on the criminal trial proceeding. So we looked at how a case moves from when it was in circuit court after it had been bounded by a grand jury, going from circuit court and then up to this process of appeals. And the next talk will kind of focus even more on a number of just some odd end topics that are still important in the legal affairs reporting beat. Thank you for your attention.